Hello, everyone. My name is Barb Navy. I'm with the Small Business Development Center at Columbus State Community College, and I'd like to welcome you to this installment of the Small Business Clinic series. Our presenter this evening is Ambrose Moses III, and he is going to fill us with wisdom about different business entities and which one would be right for your business idea. So with no further ado, I'll just turn it over to Ambrose and have had it.
All right. Thank you, Barb. Let me go ahead and share my screen to make sure everyone can see that. All right. As Barb indicated, my name is Ambrose Moses, and I'm an attorney here in the Columbus area. And tonight we're going to talk about an introduction to limited liability companies and corporations. Primarily, we'll talk about LLCs or limited liability companies, but there'll be an introduction to the other business structures as well. So by way of an introduction, a lot of times when we introduce ourselves, we talk about our name and our occupation and that kind of thing. But I think that what's important to realize and recognize is that we really wear a lot of hats. And so I just grabbed a few little images of the things that I do, I think, that sort of make up me. And most times it's going to be a matter of I'm teaching a workshop, advising people on different topics and issues, doing classes, or representing clients as well, in terms of in court or in front of different agencies, administrative agencies, things of that nature. But on this slide here, you'll also see a number of the other things that I do. There's a picture there where I'm in a workshop, where I'm learning, because that's the other thing that is really important in my life and in my role as an attorney and as an advisor for individuals and businesses, is to continuously learn. Because things are always changing, and you're always looking to improve your practices, your professional practice, your business, and things of that nature, and just as an individual. So I think that this captures it a lot. And then there's a picture on the top corner, right-hand corner of the slide, which was a painting that my daughter did for me many years back. And in that, there's all these little squares and rectangles that have adjectives or descriptions, things that come to her mind when she thinks of me. And what was very interesting, and why I include this in a number of my presentations, is because my occupation, which is a lawyer, was like the smallest, or one of the smallest blocks on the painting. So all these other things that come to mind, all these other aspects of me, are the things that she catches on to. And I think that it helps to really bring home that we are more than our business, we are more than our occupation, and we are a lot of things to a lot of people. So just make sure that as you build your business, go through your career, maintain that balance. But for our purposes tonight, I'm wearing my lawyer hat, and so I'm primarily in my role where I advise, counsel, and represent, which are the primary things that an attorney does in terms of interviewing and working with clients, and then advising, meaning to understand the client's circumstances, and then provide legal advice and analysis of the law that applies to that set of facts, and then advise the clients what their options are and what they may want to consider doing. In terms of counseling, that's where the lawyer is going to work with the client. The client is addressing business or personal decisions, whatever they may be, but the attorney, instead of giving advice, is just helping the client evaluate and work through that particular scenario. And attorneys can be very helpful when it comes to counseling and being counsel, because we work with multiple clients, and our many clients have had many scenarios, many issues and challenges, and a lot of different things over the years, which the attorney brings that knowledge and background to the table when he's working with the client that's in front of him at that given time. And then finally, represent, which is the sort of more well-known aspect of what lawyers do in terms of going into court, going in front of an administrative agency, and standing there in place of the client. So representing their interests. So advise, counsel, and represent are the things that lawyers do for their clients. Now, one of the things that you probably saw on the collage of photos and images there was my small business legal aid, which is a program under my office where it helps to fulfill sort of that mission in terms of advising, counseling, and representing, where we're looking to our purpose is sort of engaging with businesses and entrepreneurs and looking to build an ecosystem of strong, viable small businesses, and then linking them with affordable, competent professional services, legal, accounting, marketing, technology, and the other things that may be important for that business. And we do that in part by collaborating with different partners and resource organizations, such as the Small Business Development Center, or SBDC, and other organizations across the city and other parts of the state, who also look to work with and build that ecosystem for small businesses. So that's part of what we do with our small business legal aid program through my law office as well. Now, as we get into the discussion here this evening, I want to go ahead and put my disclaimer out there that we are providing legal information for educational purposes. It's not intended to be and should not be relied upon as legal advice. For legal advice, you should consult with an attorney of your choice. It could be me, or it could be some other lawyer as well. And you will notice in the corner of each of the slides this evening, there's a QR code. If you want to, if you use the QR code, then you'll be able to link to our website and get on the mailing list, or to request a consultation, one of the free consultations that we do as well. All right, so talking about business structures. Now, one of the first decisions that an entrepreneur faces is what legal structure to establish for his or her business. That's going to be a decision that the business owner is going to intentionally make for their business. They're going to consciously decide what form they want to set up, and then take the necessary steps to do that. Or they're going to just engage in their business activity, and then the law will impose a business structure or a legal structure upon their business operations. It may be that what the law imposes upon that business or that business owner is not what the owner would like to have, or it may not have the structure, the characteristics, the protections, those things that are important to that business owner. So it's important to know what those options are, and then to make consciously that decision of what structure you want to have. Now, so a question becomes, well, why is legal structure so important? That you should make a decision, or that if you don't make a decision, something is going to be imposed by operation of law. Well, it sort of breaks down to the ownership, liability, and the taxation or tax consequences of that business structure. So when we talk about ownership, we're looking at, it sort of sounds simple, but it's important to document. I have seen situations where it's not properly documented. But who owns the business? how much of that business do they own? And what does that business ownership entitle that individual to do? So these are some things that are important. And typically, it may come up when there's an issue, when there's a dispute, or if there's liability, which is going to be the next topic there, when there's liability that comes up, or there's a need for compliance with laws or regulations regarding that business, the ownership of that becomes one of the key issues as well, in terms of determining who is in charge or who's liable or who's responsible for making sure that this business does what it's supposed to do. Then the next thing that sort of takes us to the liability. So the questions that arise under the title of liability is, who must pay the debts that are owed by the business? How much of those debts do they pay? And if those debts and obligations are not paid, what assets can be taken to pay those debts that are owed by the business? Is it the assets of the business itself, or does it also include the personal assets that are owned by the individual, by the owner? So as we go into our discussion here this evening, you'll see that the form of the business or the legal structure will impact who the owners are, and it's also going to impact, in particular, how the liability is applied to that. And then finally, in terms of taxation, how is this business going to be treated for tax purposes? Which is going to be taxes, primarily we'll talk about to the federal government, but does the business pay taxes on the income and profit that are generated, or do the owners of that business pay taxes on the income that is generated or the profits that are generated from that business? And as we look at the structures, you'll see that they each treat that differently as well. Now, to give us some context for our discussion, we'll sort of tell a little story here and give us some factual background. So let's say we have a farm. You can see the produce there, some tomatoes, and there's some other things growing. And then we have John and Kelly who are at the farm, and you can see they're standing there and they're holding their tray of produce, and looks like maybe they're looking to sell that. So maybe they're engaged as a business, as a farming business. But a question would be, what kind of business are they? If they're selling, what kind of business are they? And the short answer is that it's not possible to tell just by viewing the image or viewing the outside operations of that enterprise. So we don't know if it's a sole proprietorship. We don't know if John and Kelly here are even the owners of that business, or maybe they're employees, or maybe they're volunteers. It's hard to tell how a business is structured just by looking at it from the outside. So that's the key thing to keep in mind. It's important to understand what your options are, and then to make decisions of how you're going to set that up. And it's got to be maintained in the records of your business operation. But so let's say John and Kelly are operating this farm, and in terms of whatever capacity they're in, and so they're looking to sell their produce, and folks come by and they come by the farm, and then they purchase goods from them. And so they're going to be sort of limited, because their customers are only those who happen to come by or even go to their farm as a destination. So they need some additional outlets. But luckily for John and Kelly, there was a local market that was selling organic vegetables, and they were looking for more farmers or more producers to bring inventory to them. So now John and Kelly have another outlet, so they can continue to sell at their farm, but now they're able to, if they can get their produce to that market, now they have a wider audience to whom to sell their produce, which is a good thing. So now they get to expand, they get to grow more, get to sell more, and so as a result of that, now they have to have a way to get that produce from the farm to the market. In order to meet that demand. So the business is growing, and which all sounds good, but the one thing to keep in mind is that you can't control everything that happens in your business. As you bring in other contractors, other employees. I've heard people say, over the years, different clients and other folks, oh, I'm going to be very careful. I'm not going to have any problems. I always follow through. Things happen. And so as with John and Kelly, things were going well, they were growing. And then one day something happened. So a truck was on its way to market. And as you can tell from the image, it didn't make it. So obviously there was some type of incident, and this truck, which should be on its four wheels, it's on its side, and we see that there's boxes of produce spread across the roadway. So it did not make it to its destination. So just by looking at this image, we can assume that obviously there's some property damage. There is some unfulfilled promises, in terms of the destination. Whoever purchased or is looking to purchase that produce didn't get it. There's very likely injuries that are involved in terms of the driver or maybe some other persons as well. So as a result of this, John and Kelly, their business, the business was growing. They were fulfilling some contracts, all this additional activity, and then this incident happened. So let's say that in terms of liability, this incident resulted in a claim for $135,000, because of injury or damage to persons and property, and maybe even a breach of contract because the market paid or expected to get certain produce that never got there. And let's say that the business only has assets of $125,000. So that means that there is still owed $10,000. So the question would be, must the owner of the business pay that $10,000? So the $135,000 is greater than the assets of the business. So then it wipes out all of the assets, and there's still $10,000. So who has to pay that? Well, it's going to differ depending upon the structure of the business. So if there was a sole proprietorship, the answer, or partnership, for those two, the answer would be yes, that the owners of the business would be personally liable for that remaining $10,000, which means that their personal assets, their car, their house, their personal bank account, any other personal assets they have could be used or taken to satisfy the remainder of that claim, that $10,000. If the business was a corporation or a limited liability company or LLC, then the answer would be no, that the owner's personal assets would not be taken, would not be subject to that remaining $10,000. So we can see from that the structure of the business impacts how liability is applied in that scenario. So the factual occurrences were all the same, but the way that it's treated for liability purposes differ. So we will now get into a little bit of the consideration of the options. So the primary business structures that most folks choose from, review and choose from, are sole proprietorship, partnership, corporation, and limited liability company. Now, as we compare these, we are going to use our initial considerations of ownership, liability, and taxation. So the first structure that we have is the sole proprietorship. Now, a sole proprietorship is a single individual engaged in a business activity. That individual and that business are one and the same. There's no separation or distinction between them. As a result of that, any liability of that business is a liability of that owner, which means then that in the instance of the John and Kelly, first of all, only one of them would be the owner if they were the only people involved in the business. So one of them would be the owner as a sole proprietor. The liability, that remaining $10,000, then would be a liability of that owner of the business. Now, for tax purposes, the sole proprietorship is a what we call a disregarded entity, meaning that with the sole proprietorship, there's no separation between that individual and the business. So the tax consequences, profits and losses, are the responsibility of that individual owner of that sole proprietorship of that business. So they would report their profits and losses on their tax return. They would use a Schedule C that they would attach to their 1040 to report their profits and losses from that business. And with respect to the sole proprietorship, there are no special documents or special processes needed to create the sole proprietorship. It's just an individual engaged in a business activity. So there's no special documents or filings required to establish that business entity. The next form that we have is the partnership. Now, the partnership is owned by two or more persons, which we call partners. And when we say persons, we mean persons in the legal sense, meaning that it can be an individual, it can be a corporation, it can be an LLC. So any of those could be the person that is a partner in the partnership, and it's going to require that there is two or more persons who are those partners. Now, when we talk about liability for a partnership, the partnership is viewed as a pass-through entity, so that the liability of the partnership, once the partnership assets are used to satisfy in terms of what the partnership has, any remaining liability would pass through to those partners, which is why in our example, that the remaining $10,000 would pass through, since there were no assets remaining to cover it, it would pass through to those individual partners. And so if you are in a partnership and you have personal assets and your partner does not, then it may be that that you would be liable and have to pay that remaining $10,000, and then hopefully you're going to have an arrangement where your partner would contribute their share of that, to reimburse you for their share of that obligation that you paid. Then in terms of taxation, the partnership in that situation as well is a pass-through entity, meaning that the partnership would file a tax return, a Form 1065, where it's going to tell the IRS, the Internal Revenue Service, this was our operations this year, this was our profit, or these were our losses, and it's what we call an information return. So it's telling the IRS what happened, and these were our partners and their share of those profits and losses. Then the Internal Revenue Service would look for the partners to show and report their share of those profits or losses on their personal returns. So then the tax consequences would be handled at the partner level. So the partnership is reporting information, then the partners actually handle the tax outcome and the tax payments and reporting themselves at their individual levels. Then in terms of documentation, and formalities, the partnership does require a partnership agreement, and it could be verbal, but obviously it would be better if someone if persons were doing a partnership agreement, that you have it in writing. That way, if a dispute occurs or something happens down the road, you will have it in writing of what were the decisions, how are we going to handle this, who owns how much, how are we going to allocate the profits and losses between us, how are we going to address if a partner wants to leave the partnership, can we bring a new partner in, how are we going to address that. All these kinds of decisions are things that should be done in writing so that if there's a dispute later, there's a clear indication of what the partners intended to do, and now they can either resolve that, or if they have to go to court, then they can have a judge interpret that contract or partnership agreement and then tell them, well, here's the outcome. All right. So our next form is the corporation. Now, the corporation is the most formal of the business structures that we have. And we say that it's the most formal because by statute, by law, the corporation must have shareholders, a board of directors, and officers. So shareholders are the owners of the corporation. The shareholders will elect a board of directors. The board of directors govern the corporation and oversee the major directions and decisions of that corporation. One of the things that the board of directors does is to hire the officers. So president, vice president, secretary, treasurer, those are officers of the corporation. They are employees who handle the day-to-day affairs of that corporation. So shareholders are the owners. They elect a board of directors. The board of directors will hire the officers of that corporation. In Ohio, it's possible to have a corporation that has one individual who is the sole shareholder, sole director, and sole officer of that entity. So they can wear these multiple hats. So you can have one person, one individual, who is all three of those roles within the corporation. So when we get to our comparison, in terms of ownership, the corporation is owned by shareholders. So it's one or more persons who are the owners of that corporation. Now, the corporation comes into being when articles of incorporation are filed with the Secretary of State. When that happens, the corporation comes into existence and it's recognized as a person separate from its owners. Okay, so when we say it's owned by shareholders, the corporation has been created and it's a person under the law. Then the shareholders own a piece of that corporation. Now, because the corporation is a person under the law, then it's liable for its own debts and claims, which means then that when we get to this issue of liability, the owners of the corporation, shareholders, are not liable for the corporate debts and other obligations. So there's a separation between them. So the corporation is liable for its own debts, which then is why in our example, when the accident happened, the truck turned over, the claims were made, and then the claim exceeded or was more than the assets of that business of the corporation, that $10,000, the shareholders would not be liable for that. That stays there with the corporation. If the corporation doesn't have anything to cover it with, any assets, then the corporation would be bankrupted and put out of business. In terms of taxation, because the corporation is a person itself, separate from its owners, the corporation is responsible for its own tax consequences and own tax liabilities. So the owners are not responsible for the corporate taxes. The corporation is going to file a tax return, and then it's going to pay taxes on its profits, or it's going to report that it had losses. Okay. So then in terms of the formalities or documentation, there is the Articles of Incorporation, which we talked about, which is filed with the Secretary of State that brings this corporation into existence. Then internally, the corporation is going to maintain other documents by statute, by law, it's required the corporate bylaws, the minutes and resolutions that are needed. Now, the bylaws are similar to, has some of the same kind of terms as a partnership agreement might have, talking about the structure, talking about the officers and the board and what their duties are, how certain decisions will be made, things of that nature. But then we say the corporation is a person, but how would this corporation speak if it doesn't have a physical body? That's where the minutes and resolutions come into play. The minutes and resolutions are the written decisions of the board of the shareholders when they have their meetings, written decisions of the directors when they have their meetings, the board of directors. So those are the ways in which the corporation would speak. It would have those formal written decisions, and then it maintains those documents in what's called a record book or a minute book. So finally, we have the limited liability company, or LLC, which is the most popular of the business structure that we have today. I believe is somewhere between 80 and 90% of new businesses formed are formed as LLCs, or limited liability companies. So it is a very popular structure. Now we say that the LLC is more of a hybrid business structure, because it has some aspects that are similar to a corporation, and then others that are similar to a pass-through entity like a sole proprietorship or a partnership. So as we go over this, you'll see why. So in terms of owners, the owners of an LLC are called members. And then the LLC is owned by one or more person, like I said, which are called members. And those are persons in the legal sense. So it can be individuals, corporations, or even other LLCs that are the members of an LLC. The LLC is formed when articles of organization are filed with the Secretary of State. So this is similar to the articles of incorporation with the corporation. So the formation of it is similar to that. And when those articles of organization are filed, the LLC comes into existence and it's recognized as a person separate from its owners. Now, because of that, and because of statutes that are in place, the members of the LLC, the owners, are not liable for the LLC's debts and claims. So you have that limited liability in place, similar to the corporation with respect to the shareholders. Now, when we get to the issue of taxation, this is where the LLC is the most flexible, one of the most flexible of the business entities. The Internal Revenue Service, IRS, will tax a business as either a sole proprietorship or disregarded entity, a partnership, or a corporation. So LLC is not a taxable classification itself. The LLC has to fall within one of these other three: sole proprietorship, partnership, or corporation. And depending upon the specific facts and circumstances of a given LLC, it will fall into one of these three categories. Now, by default, if there are no special elections made, by default, it will be either a sole proprietorship or a partnership for tax purposes, meaning that if you have an LLC with one member, a single member LLC, then by default, it will be treated as a sole proprietorship for tax purposes. If you have two or more members in the LLC, by default, it would be treated as a partnership for tax purposes, okay? But if the LLC wanted to be treated as a corporation for tax purposes, then there's additional documentation to be filed with the Internal Revenue Service to be recognized as a corporation for tax purposes. So it's still an LLC under state law, but for tax purposes, it would be treated as one of these three: sole prop, partnership, or corporation. So there's flexibility in the tax treatment of an LLC. Now, in terms of the documentation, we talked about the articles of organization that are filed to bring it into existence, but then you also have the operating agreement, which is a very important document within the LLC structure, and really it becomes, under the new laws in Ohio, that operating agreement becomes very, very critical in terms of the sort of the power and flexibility of that structure, because there's a lot of things that you can do, a lot of options available for how one sets up and operates their LLC, but it would have to be reflected in the operating agreement, a written operating agreement for that entity. And this is where I think a lot of times folks may sort of miss things, because if they don't have guidance from an attorney to help them put that operating agreement together, or to fashion out how they want to set up and operate their business, then they will miss out on the power of that, and the availability of the operating agreement and the flexibility of that in the structure. Then what you're going to also want to do, similar to with the corporation, is to have minutes and resolutions of the decisions that are being made within that LLC by the members, by the managers, if they decide to have a board of managers, or by the other, depending upon how they structure it, by the others within that entity who have authority to make decisions on behalf of that LLC. Now, then, as we get ready to wrap up and open it up for questions, I'd like to look at the LLC and describe it as the sort of like the Swiss Army knife of business entities, because under the new law in Ohio, it gives the LLC a lot of flexibility. So, as you can see from the image here, the core document, the core substance of the LLC is found in the operating agreement, and under the principle of freedom of contract. So as long as it's not prohibited by the law or by the statute, then there's a lot that you can have done. Whatever people want to do or how they want to structure their LLC, it can be done. It states in the statute that to the greatest extent possible, there will be freedom of contract. So there's a section that says what you cannot do, but outside of that, there's a lot of flexibility. So that means that within the LLC, an LLC can be a for-profit, or it can be set up as a nonprofit. The LLC, we talked about the flexible tax treatment, but Ohio also allows what's called a series LLC, meaning that you can have an LLC that has subsets within it that have separate ownership of assets and separate operations. So it's a way to build in multiple components under the umbrella of one LLC. For instance, if the LLC was engaged in one simple example, real estate, and there were three houses or three buildings that the LLC was going to own or going to purchase, then there could be a separate series for each of those properties. So there's three properties, there will be three series. One might be a single family home, one might be a multi-family apartment building, and then the third might be a commercial building. So they're each owned under a separate series. If there was an incident on the commercial real estate, the commercial property, and let's say the property was worth $100,000, and there was something that happened, and there was a $500,000 claim. So there's $400,000 that still needs to be collected. Well, that series would be responsible and liable for that full $500,000. The other two series would not be exposed to or liable for any portion of that $500,000 claim. So even though they are all three under the same umbrella of this LLC, they're in separate asset, what's called separate asset series, and so the liabilities don't spill over to the other series. So this is a one way to sort of limit some of the liability or exposure of different properties within that one entity. But there are a lot of different things that could be done within a series of an LLC. So a series LLC is a new feature under Ohio law, and it gives a lot of flexibility to the entities as well. And then also, when we talk about the Swiss Army knife aspect, then we have the privacy and anonymity. So being able to set up your entity and not necessarily have your personal name you're on the public record in terms of ownership of different assets or businesses. You can have things that are owned by your LLC and not necessarily have to broadcast to the world your personal ownership or control of those things. And then just a creative ownership and management. And that's where I was talking about in terms of the flexibility that's involved, that's available for how you want to structure that. So finally, our definition of a complete LLC is one that is properly formed and has created and maintains all of the required documentation to evidence its existence, its ownership, and its decisions. So a complete LLC is one that is properly formed and has created and maintains all of the required documentation to evidence its existence, ownership, and decisions. So the existence is shown by the articles of organization. So that's on the public record. Ownership is an aspect that's going to be shown through internal records of the LLC by the operating agreement, maybe a membership log, and then also any minutes and resolutions of that LLC that relate to the ownership of that entity. And then finally, the decisions of the LLC would be reflected in the minutes and resolutions and decisions within that entity. And so as a diagram, that's what this image here shows. It shows the different components, that the entity is properly formed. That's where you have the articles of organization and operating agreement. Then the evidence of that existence, your certificate that you get back from the Secretary of State, then again, the operating agreement. And then you may have, going in between here, the statement of authority, which is a new provision under Ohio law, which is where the LLC can put on the record who has the authority, what individuals or positions within the entity have the authority to sign or enter into contracts or to exercise the authority of that LLC. And then again, the operating agreement. And then finally, in terms of the evidence of decisions, you're going to have the minutes and resolutions that we talked about, and the operating agreement that go with that. So that was quite a bit. I hope I didn't talk too fast for everyone. And I would like to sort of open it up if you guys have any questions.
Well, I will give first opportunity to our audience here, because I actually did write down some questions myself that I think would be beneficial to a lot of people. But is it Tian? If you have any questions?
Yes, it's Tian. Hi, Mr. Moses. This was a lot of great information. I learned a lot. There was stuff in here that I didn't even think about. The whole liability with the truck thing. I'm really interested in an LLC. So my question is, there's two things. Could you elaborate on that new law that you were saying that your LLC can own like different things, but you don't want to broadcast, that your LLC owns whatever those items or, can be. And then The other question I have with filing your LLC, that's done with the Secretary of State, I believe. And when you file that, um, do you also do like that owners of article and the decisions and the other thing that you mentioned, is all that filed with the Secretary of State when you apply for your LLC?
Okay, so
Great question.
yeah, those were good questions there. So in terms of the privacy and the anonymity, what we were referring to is that the let's say if you don't want your personal name on the record, then you would have someone, let's say you would go to your lawyer. Your lawyer would file the articles of organization, and your lawyer's name shows up as the organizer of that entity. So that's what's on the public record. And if your attorney or someone else is the statutory agent, then your personal name never shows up on the public record. So it's only your entity, and then whoever the organizer or the statutory agent are that are on the public record. Now they have to be legitimate people, and have to be able to be contacted, but your personal name is not on the public record. With respect to the documentation that gets filed, when we talk about the documentation required for the entity, in Ohio, only the articles of organization have to be filed with the Secretary of State. So when that occurs, then the entity comes into existence. The other documents, the operating agreement and your minutes and resolutions, are maintained internally. So you create them, they get created, but they are maintained internally within the company. Now, and so then when their times come up, company may want to go get certified as a minority business enterprise, or a female business enterprise, or a veteran-owned business. So there may be a need then to show some of those documents to one of the agencies that are regulating that. But they are maintained internally within the company. They're not on the public record, in Ohio at least. They're not on the public record.
Okay, thank you.
Mm-hmm. You're welcome.
Well, Ambrose, to follow up on the question about this filing for the Series LLC, do you have to claim that in your filing, and how do you do that? Is that part of your articles of incorporation? And how is that different from just say filing for a different DBA or trade name?
So the law does require, in terms of doing a Series LLC, Ohio law does have special procedures that have to be followed. So so there is a need for adding certain language into the articles of organization, and then also into the operating agreement. So this is where a lot, I think, when I talked about a lot of times, I think a lot of people will go down and file on their own because it looks simple to go to the Secretary of State site, put in a little information, and then pay your $99, and then you get your certificate. But simply doing that, you don't actually take advantage of those things that are allowed for under the statute, under the law. So if you wanted to do a Series LLC, there are certain things that have to be done even at that formation stage. If you wanted to structure your LLC to maximize your privacy and anonymity, that's a decision you're going to want to make before you file anything, because then you have to take necessary steps to keep your name off of the record. If you file on your own and you put your name down as the organizer, or you put your name down as the initial statutory agent, then even if you change it later to someone else, your original name is there. So all the history is still going to be there on the public record. So if you're looking to maximize the structure, looking to maximize that anonymity, in privacy, then you're going to probably want to talk with legal counsel, let your attorney know what you're trying to do, and then follow his or her advice in terms of that of that structure.
How difficult is it to change from one form of filing to another? Do you have to
Ohio
and reopen, or?
Well, no, you don't necessarily have to close and then reopen. Ohio has some procedures that allow for what's called conversion on the record, which allows then for an LLC to convert into a corporation, or a corporation to convert into an LLC. So there are special provisions that allow for that.
And you had mentioned a number of times that what Ohio allows. So so you should assume that the way things are in Ohio aren't necessarily the way they are in other states. And at what point would you need to say file your company or register your company in more than one state?
So you're going to want to talk with legal counsel about that, from the standpoint that engaging in business in a state, or if you're considered as engaged in business in that state, then you're going to have to comply with their law if it requires you to register as a foreign entity. So you could be in Ohio, you could have an Ohio LLC, and let's say it's going to also operate in Indiana, or have an office, or have some salespeople in Indiana. Then it may need to also register as a foreign LLC in Indiana. So its home state is Ohio, and it would be an Ohio LLC, but then registered as a foreign LLC in Indiana, if that's what Indiana's law requires. So each state, the law does differ in each state from that standpoint.
And does shipping product to an out-of-state address constitute doing business in another state? Or does that depend on how the state?
Generally, I'm going to say it depends. I don't want to give the wrong advice here.
Small business attorney.
It's really going to depend upon what that state, what all the facts that are involved, and what that state says. That what constitutes doing business in our state. Many times just shipping something to a state might not really say, hey, you're operating here, but the facts and circumstances are going to really depend there.
Great. And what can someone expect if they realize that it would be a really good idea to consult an attorney? What could a small business owner typically expect from their first meeting with you?
So in terms of with my office, I do have what's called a small business legal aid connection call, which is just a free sort of 15-minute call where we just talk introductory, what your issue is, what the concern is. So it's really just sort of establishing that rapport and evaluating if it's something to even go further on in terms of doing a full consultation, or if it's something that's completely outside of what I would work on, and so maybe even just go see another lawyer for that particular issue. So really, I like to look at it as a way to sort of just be introduced and start building a rapport. The primary thing, and I think that business owners should look to, they can talk with a few different attorneys. You're really going to want a professional who you can engage with, who understands you and who you understand, and as you talk about topics, and as they bring topics and options and issues to you, that you'll understand it, Or if you have a question, you feel comfortable asking, hey, what does this mean? Or can you tell me more about that? Because sometimes people don't. So I think it's important to be able to have a good relationship, and rapport with your professional advisor.
Absolutely. Absolutely. All right. Or any other questions? All right. Well, thank you very much for your time. This was very informative, and we will be posting this on our YouTube account too eventually after we go through the processing of it. But just want to
All
make sure
right.
that anyone has the chance here to capture the QR code or the contact information. And we really look forward to working with you in the future. And hopefully you can help a lot of new businesses get started.
All right, all right. Looking forward to it, and thank you for having me. It's always a joy to interact, to work with SBDC, and to engage with the folks who come to the different classes.
All right.